Good afternoon, class. This is my video on the Fifth Amendment. What is the Fifth Amendment? It's the right to a grand jury, forbids double jeopardy, protects against self-incrimination, and its due process. According to the Legal Information Institute, the Fifth Amendment is defined as no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment of indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Source: Legal Information Institute, no date. Requirements of the Fifth Amendment: self-incrimination. Self-incrimination is the act of implicating oneself in a crime or exposing oneself to criminal prosecution. Source: Legal Information Institute, no date. This can occur as a result of interrogation or may be made voluntarily. Source: Legal Information Institute, no date. Self-inculpation is another term for self-incrimination. In addition to the Fifth Amendment, various federal laws in regards to self-incrimination can provide protection. Several cases in the Supreme Court have gone further to the determination of self-incrimination. Malloy v. Hogan, the Supreme Court stated, when determining if state officers properly obtained a confession, one must focus on whether the statements were made freely and voluntarily without any direct or implied promise or improper influence. Source: Legal Information Institute, no date. In the Supreme Court case of Griffin v. California, the Supreme Court held that at trial, if the accused invokes his Fifth Amendment right not to self-incriminate, neither the prosecution nor the judge may tell the jury that silence is evidence that the defendant is making an admission of guilt. Source: Legal Information Institute, no date. The Supreme Court held that in the case of Miranda v. Arizona, when an individual is taken into custody or otherwise deprived of his freedom by the authorities in any significant way and is subjected to questioning, the privilege against self-incrimination is jeopardized, therefore finding self-incrimination protections in the Fourth Amendment. If the individual is not made aware of his rights, including the right to an attorney and the right to remain silent, then self-incriminating statements the individual makes will be inadmissible in court. Legal Information Institute, no date. Rights to remain silent, Miranda decision. Steps officers must take to gain incriminating statements admissible in court, in trial. The Miranda warnings originated in the U.S. Supreme Court ruling, Miranda v. Arizona, which set forth the following warnings and accompanying rights. You have the right to remain silent. Anything you say can be used against you in a court of law. You have the right to consult with a lawyer and have that lawyer present during the interrogation. If you cannot afford a lawyer, one will be appointed to represent you. You can invoke your right to be silent before or during an interrogation, and if you do so, the interrogation must stop. You can invoke your right to have an attorney present, and until your attorney is present, the interrogation must stop. Source: FindLaw 2019. However, the Miranda warning may not apply in certain situations. Two very basic prerequisites before the police are required to issue a Miranda warning to a suspect is the suspect must be in police custody and the suspect must be under investigation. Source is FindLaw 2019. In understanding these situations, if a person is not in a formal situation to be in police custody or being interrogated, then you are not warranted the right to a Miranda warning. This creates an advantage for police in gaining incriminating statements admissible in trial. The police can use anything you say until those two requirements are fulfilled as evidence against you. FindLaw 2019. Another way officers may obtain incriminating statements admissible in court comes from a case in which the U.S. Supreme Court stated, police officers could initiate a second interrogation of a suspect who had previously invoked his Miranda right to remain silent once 2 weeks had elapsed from the date of the original interrogation. The police did not have to give the suspect another Miranda warning, according to the Supreme Court. The court decided that the Miranda warning from the previous interrogation remained in effect. Thus, the statements the suspect gave during the second interrogation constituted a waiver of his right to silence. Source: FindLaw 2019. Motion to suppress granted for a violation of the Fifth Amendment. Remedy for the defendant. The process of a motion to suppress is started by the defense attorney, who files a motion with the court asserting the legal grounds on which the evidence should be excluded. Depending on the type of motion to suppress, the court may hold an evidentiary hearing where witnesses testify and are questioned by both the prosecution and the defense. Attorneys for both sides then have an opportunity to present legal arguments about whether the evidence should be excluded. After argument, the judge will issue a decision. If the motion to suppress is allowed, the Commonwealth may not be able to go forward with the prosecution, depending on what, if any, additional evidence it has against the defendant. Sources: Capella Law Offices 2019. The remedy would be in favor of the defendant, in which the prosecution may not continue. Filing a motion to suppress can be one of the most effective ways to defend a criminal case. A motion to suppress should be filed when the facts and law strongly support a conclusion that the police violated a defendant's rights. But there may also be a good reason to file a motion to suppress even when the facts and law are not as strong and it is unlikely that the evidence will be suppressed. This is a strategic move that allows a defense attorney to cross-examine police on the record and gain insight on the prosecution's case. If and when the case goes to trial, the information obtained during the motion to suppress may be useful and help build a defense. For example, a motion to suppress hearing may provide a chance to obtain detailed information from police officers or other witnesses who would not otherwise be willing to speak to the defense, or to obtain impeachment material for use at trial. Specifically, if a police officer says two different things during the hearing and trial, then having an inconsistent statement on record will often help show that the police are not credible. Source: Capella Law Offices 2019. And here are my references for this. Capella Law Offices 2019, Motion to Suppress, FindLaw 2019, Miranda Warnings and Police Questioning, Legal Information Institute, no date, Fifth Amendment, and Legal Information Institute, no date, self-incrimination. Thank you.